Okay, let's try and unpack this. We're talking a massive $8 billion claim.
Right.
Some of the biggest names in tech, top executives, right on the hook.
Yeah.
And then a trial that just evaporates. Lasts one day.
Astonishingly quick, wasn't it? Especially, given what was coming. That testimony everyone was waiting for.
Exactly. So today, we are diving deep into the Meta shareholder derivative lawsuit, the one targeting Mark Zuckerberg, other key figures there.
Mm-hmm.
And our mission really is to give you a shortcut to understanding this because, well, it feels like a landmark case for tech accountability.
It really does. It shifts things, potentially for corporate leadership and crucially for how your data is handled.
And the timing adds this layer of, well, intrigue, doesn't it? Just yesterday, July 17th, 2025, this surprise settlement comes out of nowhere.
Right before Zuckerberg and Sheryl Sandberg were due to testify publicly.
Averted, gone, leaving big questions about transparency just hanging there.
Definitely. So, okay, let's break it down. What exactly was this lawsuit? Who brought it?
Right. So it wasn't your standard lawsuit against the company. It was what's called a shareholder derivative lawsuit.
Which is different. Explain that a bit.
Well, investors, like Amalgamated Bank in this case, they file the suit, but they do it on behalf of Meta, for the company itself.
So the goal isn't for the shareholders filing the suit to get a payout directly.
Exactly. The goal was to force the executives, the ones allegedly responsible, to pay Meta back, reimburse the company for billions it lost in fines.
Billions with a B. Like
Right.
that huge $5.1 billion FTC penalty.
And the $725 million user settlement, too. The idea is making the company whole after, well, alleged mismanagement.
Okay, got it. And the root cause, the spark for all this, it was Cambridge Analytica, wasn't it? Back in 2018.
That's the core. The central allegation was that Meta's leadership knew they were violating a 2012 FTC consent order. They knew.
Basically running what the lawsuit called an illegal data harvesting operation. That phrase, knowing violation, is so important here.
Why specifically?
Because it suggests it wasn't just a mistake or, an oversight. It points towards a deliberate decision to ignore a legal agreement about user data. Real accountability implications there.
And it went beyond just the privacy violations. There were other serious claims, too.
Oh, yeah. Like misleading investors about their practices back in, I think, 2016 filings.
Right, and improperly approving that massive FTC fine, the $5.1 billion one, allegedly to protect Zuckerberg personally.
Shield him from liability. Plus, there were those insider trading accusations against Zuckerberg.
Though he denied that, said the stock sales were all pre-planned, part of a standard process.
And we can't forget the spoliation claim against Sandberg, failing to preserve emails.
He's actually sanctioned for that, right? For
Right.
emails on her personal account.
Yeah, spoliation, basically hiding or destroying evidence that's serious. It really throws a spotlight on how executives communicate, especially using personal accounts for work stuff.
So with all these heavy allegations,
Mhm.
this clearly wasn't just another day in court. It was a unique kind of legal fight.
Definitely unique, especially because it involved what's called a Caremark claim.
In the Delaware Chancery Court, which is hugely influential in corporate law.
Exactly. And Caremark claims are, well, notoriously difficult to pursue. Very rare.
Why are they so tough?
Because you're essentially arguing the board completely failed in its duty to oversee the company. Not just that they made a bad call, but a total failure of oversight.
It cuts against the usual protections executives have, the business judgment rule.
Precisely. So the fact this case even got to the trial stage, particularly after that enormous FTC fine landed, it really signaled maybe the courts are taking a stricter line now.
A tougher stance on board oversight, especially around data.
Seems that way.
Then comes the big twist, the settlement. But the terms are confidential, undisclosed.
Right. So Meta gets some money back, presumably, which is good for the company financially.
But it immediately sparked criticism, didn't it?
It did. Accountability advocates jumped on it, calling it a missed opportunity for public accountability.
Because we don't get the details. We don't see the evidence laid out.
Exactly. It kind of masks the full picture of who knew what, when, and what decisions were actually made. The company gets paid, maybe, but the public, the industry. We don't get the full story, leaves a lot of questions unanswered.
So bringing it all together.
Yeah.
What's the big picture here? What does this mean for you listening?
I think this case, especially alongside others, you had Yahoo's $29 million derivative settlement, Google's $350 million security settlement over data issues.
There's a clear trend emerging.
Definitely.
Yeah.
Data privacy failures aren't just a PR problem or a regulatory fine anymore. They're now directly causing massive corporate losses.
And that crucially, is leading to personal liability for the executives at the top.
Yes. It elevates data privacy from just an IT issue or a legal compliance task to a fundamental fiduciary duty, a core responsibility of the board and C-suite.
It's not just the company paying a fine. It could impact executives directly, their careers, their assets.
That changes the calculation significantly. So I guess the final thought to leave people with is this. Yeah. In this age where data is everything, and we're seeing more scrutiny, but also these powerful behind closed doors settlements, what does this quick meta resolution really tell us about transparency, about accountability, and how corporate governance is changing, or maybe not changing enough, in the digital age?
Something to definitely mull over.